When the indictment that was brought against former President Donald Trump was unsealed last week in a Miami courtroom, it laid down 37 specific counts that were made against the former president. The first 31 relate to each document that he had in his possession that the Department of Justice feels like he should not have had under the law. The last 6 items relate to things about those particular documents. Now, in case you're wondering what exactly Trump is in violation of, at least according to the Department of Justice, it relates to a very old law that goes back to the turn of the 20th century, the Espionage Act of 1917. What I want to do in this video tonight is give a brief introduction to what the Espionage Act is, but also show you what other lawyers are saying, that Trump may not be in violation of anything at all because of an act that would supersede the Espionage Act. Sound a little confusing? Sound like you need a lawyer? Well, I'm no lawyer, but hang on. We're going to try and get through all this in just one second. My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk. So the indictment has been unsealed. We know that there are 37 different counts that have been brought down against former President Trump. But what everybody is really having a hard time getting their arms wrapped around is just what exact law did he violate? Well, the Department of Justice has a very definitive opinion about which law that was. It's called the Espionage Act of 1917. So what I'm going to do is give a brief introduction to what that law is, and then we'll give a look at what it is people are saying trumps, no pun intended, the Espionage Act, and why it is that law that trumps the Espionage Act is more important than the Espionage Act itself. I know, it's a little convoluted, but stick with me. Uncle Front Porch will make it real clear here in just one second. So we're going to start, interestingly enough, with People magazine. Espionage Act explained. Trump is the first U.S. president charged with violating the 1917 law. Article written by Virginia Chamley and Aaron Parsley. Bombshell news that Donald Trump had been indicted on at least 7 criminal counts Thursday sheds light more on a startling aspect of the federal investigation into the alleged mishandling of White House documents, that the former president is being accused of violating the Espionage Act and other laws related to national security. A little further into the article, what is the Espionage Act? The Espionage Act was first enacted by Congress in 1917 during World War I and makes it illegal to obtain information, including photographs or documents, related to national defense, and here's the important part, with the intent of that information being used against the U.S. or to benefit a foreign nation. 3 sections of Title 18 of the United States Code are listed on the warrant that was used to search Trump's Mar-a-Lago home for documents in August 2022. Section 793 covers the unlawful retention of defense-related information that could harm the United States or aid a foreign adversary. Section 1519 covers destroying or concealing documents to obstruct government investigations or administrative proceedings. Section 2071 covers the unlawful removal of government records. Now remember that last section because that's going to be important a little later down the line. Prior to Trump, no U.S. president in history has been investigated for violating the Espionage Act. Okay. That, ladies and gentlemen, broadly speaking, is what it is he's accused of. Now I want to dig a little deeper into the Espionage Act. I'm going to show you an article written by Michael Barone, which, by the way, if you're not familiar with his work or his writings, Michael Barone has been around for years. He is an expert in American electoral politics. This guy can tell you right down to the precinct level where votes are going to come from. He has written the Almanac of American Politics now going on, God, probably 20 or 30 years. And if you really want a primer on understanding election politics in America, you need to follow his work. A very scholarly, very smart man. But he wrote an article back in August of 2022, which was published at Real Clear Politics. Take a look at this. The Espionage Act of 1917 once again rears its ugly head. Now, if the date of publication on this article sounds familiar, this was around the time of the Mar-a-Lago raid. But what I want to do with this is get deep into the article and show you a couple of parts about the Espionage Act that make it so controversial. In Michael Barone's article, the Espionage Act was passed with bipartisan support and supplemented by a Sedition Act banning, quote, abusive language. Now, by way of historical context, the Sedition Act of 1918 was allowed to expire. It was never renewed, and appropriately so, because it was a serious impediment to free speech. But getting a little further into this, the overbreadth of the Espionage Act makes this easy. In other words, government being able to prosecute individuals. The law's section 793D says that, quote, a person lawfully in possession of information that the government has classified as secret who turns it over to someone not lawfully entitled to possess it has committed a crime. Hence, espionage. A further section, 793G, it's a conspiracy count that says that anyone who conspires to help a source hand over such material has committed the same crime. In other words, a lot of journalism could be prosecuted as a felony, and so could a lot of conduct by former government officials, even presidents. This gives government prosecutors a license to target and jail political opponents, as Wilson targeted and jailed Eugene Debs. And that is historically true. That's what the Espionage Act was used for many years ago. Now, that's basically what the law is. Now, here's the rub. For those who are coming to the defense of former President Trump, they are citing another law which, in their opinion, supersedes this one. So hang on, folks. We're going to get into what that is in just 1 second. Now, as you might expect, there are a lot of people who are coming to the defense of former President Trump. Lawyers, non-lawyers, politicians, senators, congressmen, etc. But there are 3 lawyers in particular who I've been paying attention to because they've been making a very salient argument as it relates to why this entire indictment never even should have been brought. I'm going to show you snippets of what they've been saying and show you the one law that they are referencing that, in their opinion, and frankly I don't disagree with them, winds up superseding the Espionage Act as far as weight and importance in this matter. So we're going to start first with Mike Davis. If you're not familiar with him, he is the head of the Article 3 project. I want to show you a tweet that he put out, and he brings up a very valid point. So take a look at this. Just reread Biden AG's Merrick Garland's indictment of Trump. The Presidential Records Act, not the Espionage Act, applies to a former president's handling of his classified records. But even if the Espionage Act somehow applies, what is the allegation, let alone the evidence, that Trump intended, quote, injury of the United States or to the aid of a foreign nation? Now, that last part, that quotation, injury of the United States or to the aid of a foreign nation, references a decision that came down in 2006-2007 called United States versus Rosen. I want to read part of that and then explain why it's so important. So let's go back to that for just 1 second. This is directly from U.S. v. Rosen. Rosen requires that to establish a prosecution for conspiracy to violate Section 793D and E, which is the Espionage Act, by orally disclosing national defense information, I'm assuming that's what NDI stands for, the government must prove beyond a reasonable doubt that at the time they entered the unlawful agreement, the defendants, number 1, knew that the information the conspiracy sought to obtain and disclose was NDI, knew that the information was closely held by the government, and the disclosure of the information would be damaging to the national security. Number 2, knew the persons to whom the disclosures would be made were not authorized to receive the information. Number 3, knew the disclosures the conspiracy contemplated making were unlawful. Number 4, had reason to believe the information disclosed could be used to the injury of the United States or to the aid of a foreign nation. And number 5, intended that such injury to the United States or aid to a foreign nation result from the disclosures. Ladies and gentlemen, boil it all down from the legalese, and basically what U.S. v. Rosen is saying, that at the moment the accused shared this national defense information or non-disclosed information, however you want to break NDI down, basically that the person doing this knew very good and well this stuff was secret, knew very good and well they were giving it to someone who didn't have clearance, knew very good and well this was going to cause injury to the United States, and had the intention of doing so. Now, I want to back up and ask a question. Does anybody really believe that Donald John Trump intended to give away national security or intelligence secrets of the United States government to an individual who would either use that information themselves or give it to someone else such that it would injure the United States of America? Now, you can love Donald Trump, you can hate Donald Trump, but there's one thing about Trump you gotta say: the man loves his country. I mean, anybody who's put up with what he's put up with since 2015 has got to love America. Now, like I said, you can love him or hate him, but there's no way that you can look at what was done from the time he left office till the time of the raid at Mar-a-Lago in August of 22 and come to the conclusion that Trump was doing what he was doing with the express purpose and intent of injuring the United States. And where's the proof of the injury? Okay, so he had documents in his possession. Where's the injury? Where's the proof that he's going about trying to hurt the United States? And that's the point that Davis is making, that even if the Espionage Act applies, you've got to be able to prove that. And I'm sorry, that is an uphill climb as steep as trying to go up Mount Everest. But what is this Presidential Records Act that Davis keeps? This is an article from the Wall Street Journal, just came out today. And this is probably the best explanation of what it is and why the PRA trumps the Espionage Act. This is written by Michael Bekesha. Headline: Trump's boxes and Clinton's sock drawer. Sounds a little odd, but hang on, we'll explain what we're getting to here. Although the indictment against Donald Trump doesn't cite the Presidential Records Act, the charges are predicated on that law. The indictment came about only because the government thought Mr. Trump took records that didn't belong to him, and the government raided his house to find such records. This should never have happened. The Presidential Records Act allows the president to decide what records to return and what records to keep at the end of his presidency, and the National Archives and Records Administration can't do anything about it. I, Michael Bekesha, know because I'm the lawyer who lost the Clinton sock drawer case. All right, let's back up for a second. The case that he's referencing goes back to early 2011, 2012. And to save a little bit of reading in this article, basically what it is this. Former President Clinton, from the time he came into office to the time he left, had certain audio recordings made of certain people that he was talking to about national security issues, domestic issues, things going on in the world, and generally his views on some things. He never reported to the National Archives and Records Administration that he had these tapes. They did contain national security information. Okay, now that sets up the rest of this article, so let's get a little further into this. Let me show you what we've got. The White House made the audio tapes. Nancy Heinrich, the director of Oval Office Operations, set up meetings between Messrs. Clinton and Branch, was involved in the logistics of the recordings. Did that make them presidential records? The National Archives and Records Administration was never given the recordings. As Mr. Branch tells it, Clinton hid them in a sock drawer to keep them away from the public and took them with him when he left office. Now keep that in mind. He never told the National Archives he had these records and took them with him. My organization, again, this is Michael Bekesha speaking, Judicial Watch, sent a Freedom of Information Act request to NARA for the audio tapes. The agency responded that the tapes were Mr. Clinton's personal records and therefore not subject to the Presidential Records Act or the Freedom of Information Act. Judicial Watch sued in federal court and asked the judge to declare the audio tapes to be presidential records, and because they weren't currently in National Archive and Records Administration's possession, compel the government to give them. Or I should say get them, I'm sorry. In defending NARA, the Justice Department argued that NARA doesn't have, quote, a duty to engage in a never-ending search for potential presidential records that weren't provided to NARA by the president at the end of his term. Pay attention to what's about to be said next. Nor, the department asserted, does the Presidential Records Act require NARA to appropriate potential presidential records forcibly. The government's position was that the Congress had decided that the president and the president alone decides what is a presidential record and what isn't. He may take with him whatever records he chooses at the end of his term. Okay, let's back up a second. Very important point. I'm going to read that again. He may take with him whatever records he chooses at the end of his term. Judge Amy Berman Jackson agreed, quote, since the president is completely entrusted with the management and even the disposal of presidential records during his time in office, she said, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. One last paragraph, and then we're going to start giving some commentary. Judge Jackson added that, quote, the Presidential Records Act contains no provision obligating or even permitting the archivist to assume control over records the president categorized and filed separately as personal records. At the conclusion of the president's term, the archivist only assumes responsibility for the presidential records. The PRA does not confer any mandatory or even discretionary authority on the archivist to classify records. Under the statute, this responsibility is left solely to the president. Ladies and gentlemen, now you begin to understand why the PRA, the Presidential Records Act, is such a powerful defense to Trump. Because keep in mind, this is a district court judge who basically said, look, he takes them with him, they're his. Which sort of begs the question, if that's the case, then what are we arguing about here? This is crazy. You can't claim the Espionage Act. If the president takes them out of the White House, they are considered his personal records. That's not my opinion. That's the opinion of a federal judge. Now, I want to point out something, and I can't show you the whole thing because it would take way too long, but I want to show you a video reference from Robert Barnes, another defender of the president in this matter. He makes the valid and appropriate point. Article 2 of the United States Constitution gives all executive authority to the President of the United States, not the bureaucracy, not some archivist at the National Archive and Records Administration, not anybody else. If the president deems the document is not classified, he walks out the door with it when he's done with the presidency. It's his. He can do with it whatever he wants. Now, I mentioned in a live stream over the weekend, should he have some of these things? Well, maybe, maybe not. But then again, it's his or her sole discretion as to whether they keep them. Now, I'm going to post a link to this video in the comments section of this video when it goes up online. But check out Robert Barnes. He gives an absolutely full-throated defense and an education on the Presidential Records Act. One last point. And this relates to another reason why this whole indictment is problematic. Take a look at this. This is a tweet from Jeffrey Clark. Used to work in the Justice Department. Why did they do all the grand jury proceedings in D.C.? Why did they pierce President Trump's lawyer-client privilege? Now, I bring this up to point out something. Part of what is referenced in the indictment are recordings of comments that President Trump made. They're put in such a way that they sound very damning of the former president. Well, that sort of begs a question. How did the Justice Department get these recordings? Well, a lot of people are saying that Trump's lawyers were squeezed to the point that they gave them up. That's violation of attorney-client privilege, ladies and gentlemen. That right there could probably get this whole thing thrown out before the government ever gets started with the prosecution. So there are some valid defenses out there right now, and I tell you what, my take on it, I'm sorry. The Espionage Act for years has been argued against as being overly broad. I mean, hell, I could be committing a violation of the Espionage Act right now. You might be committing a violation of the Espionage Act. That's how broad the language is. And people have been arguing that we ought to do something about it for years, but it's kind of one of those laws that's hung around. Shouldn't really be there, but it is. But honestly, if Judge Berman's opinion from the D.C. Circuit stands about the Presidential Records Act, okay. Didn't notify NARA, didn't notify anybody else. Trump takes him out of the White House when he leaves on January 20th, 2021. Guess what? They're his. Clinton didn't declassify any of those tapes. He didn't declassify any of the information on them. He went even so far, he didn't want anybody to know about them. He put them in a sock drawer. At least everybody knew where the documents at Mar-a-Lago. And on top of that, which is not being reported widely, they were kept in a SCIF, a very secure area. But yet we're going to try and prosecute Trump over this? Over records that, according to the PRA, are his anyway? For him to do with whatever he wants? Kind of sounds kind of crazy to me. But anyway, take a look at Mike Davis, take a look at Jeff Clark, take a look at Robert Barnes. As we start to wrap this up, please do me some favors. Number one, if you are not a subscriber to this channel, please do so. Number two, please share this video around with friends of yours. Number three, give me a thumbs up. Number four, please leave a comment. My name is Brian Trippett. I am your Front Porch Conservative. I'll see you next time.